Welcome to part 2 of the Law of Code Crypto in Canada series. The following is a conversation with Grant Vingoe. He's the CEO of the Ontario Securities Commission, Canada's largest securities regulator. Grant serves concurrently as vice chair of the International Organization of Securities Commissions. That's IOSCO. Now, thank you to the sponsors who make these episodes possible, including the presenting sponsor, Altitude, as well as the others who are in the show notes below, including Canadian law firms McCarthy Tétrault and Osler. And thank you for joining me. It's always a privilege to be in your headphones or in your car stereo, however you're listening. Well, Grant, thank you so much for joining me, for having us here at the OSC's offices. It's a real treat to be able to speak with you.
Oh, it's my pleasure to join you here today and at the OSC, and I'm really pleased to be able to speak on behalf of the OSC and address your questions.
When I was in Washington, I had a chance to speak to Commissioner Peirce of the SEC about her personal philosophy to capital markets, why she thinks her work's very important as a commissioner. And I'd love to hear you talk about what brought you back from New York, why you've taken the job at the OSC, and why capital markets in Canada are important to you.
Well, I practiced law in New York City for almost 30 years, but my practice was really devoted to cross-border securities transactions and advice. And, my client base at the time was mainly Canadian organizations doing business in the US. And I got quite involved in public policy related to securities regulation to try and, bring about changes to reduce barriers to cross-border trade in financial services, essentially. And then I actually had the opportunity to become a board member of IROC, the SRO for the Canadian securities industry. And that introduced me to public policy issues as well. So I did that for about 8 years. And then I had the opportunity to come back to Canada at a senior level to really participate in public policy at the highest level, at the country's largest securities regulator. And that was something that I always aspired to and had the good fortune of being able to do it after having a lot of experience on the ground practicing law in New York.
Oh, yeah. And also seeing how securities regulation works in different countries, too. I'm sure a lot of the cross-border work you did informed how you approach your job now.
Well, I've always felt that a comparative viewpoint to securities regulation really informs policy development to see different solutions. Like a lot of people might think that Canadian and U.S. securities law is very, very similar and the underlying principles are the same, but the details and nuances can be very different, and we can learn a lot about different approaches and solutions by applying a comparative viewpoint, even between jurisdictions as similar as Canada and the U.S.
Oh, yeah. And as someone who was a securities regulatory lawyer, those details are what separates all the regimes, right? And they're so important too.
Absolutely.
And so you recently also became the vice chair of IOSCO. Congratulations.
Thank you.
For that, which is awesome. Can you explain what IOSCO is for people and what your role encompasses now as vice chair?
So IOSCO is the International Organization of Securities Commissions. So it's an international standard setter for securities regulation. It brings together all of the significant securities markets and jurisdictions from around the world. And it's a forum for exchanging information among securities regulators about emerging developments, for doing research into those developments and considering whether standards should be developed. So it's a global forum for information sharing, development of new standards, research. And my role as a vice chair is to support the organization's work plan, help develop it, and represent IOSCO in different forums, including with respect to some financial stability board committees.
And some of the things you mentioned with IOSCO, standard setting, research, sustainability, global standards, those are all things that I think affect the digital asset industry. What role does IOSCO play when it comes to digital assets?
Well, it plays a very significant role. There's a fintech task force that had to grapple, as we all did as regulators, with the emergence of crypto assets over a number of years. So initially, their role was really to determine how crypto assets would generally fit within the securities regulatory infrastructure to identify particular risks associated with it, including risks from an investor protection standpoint, risk related to custody and the loss of assets, the treatment of crypto assets under insolvency regimes, and ensuring that investors understood those risks. And initially, there were many jurisdictional battles and viewpoints which had to be clarified. And IOSCO was a very good forum for an exchange of information in that regard. And, as well, the enforcement capabilities through the MMOU were relevant when that was a necessary tool as well.
And in Canada, our securities regulators are structured a little differently than our friends in the United States. We don't have one securities body, but we do have the CSA. And I know you're here in your capacity to speak as CEO of the OSC. Could you explain for people who might not be familiar how the CSA is made up and how the different securities regulators of our provinces fit into that picture?
Yeah, so we don't have a national securities commission, and there was an effort to produce through delegation a cooperative national regulator that never came to fruition. So we have an umbrella organization called the Canadian Securities Administrators. It has an elected chair from the members. The members are the 13 provincial and territorial securities commissions, and the way it's worked out at the moment, Stan Magidson, who's the chair of the Alberta Securities Commission, is the chair of the CSA, and I serve as the chair of the Policy Coordination Committee. And a lot, follows from the name of that committee, because one of our primary efforts is to harmonize securities regulation across the country. So, we don't have a monolithic SEC type body, but we have a very effective mechanism for reconciling regional differences and making decisions among the chief executives of the CSA jurisdictions that ends up producing a result that really incorporates regional differences and specialization. As you know, the Montreal Exchange is a derivatives exchange, and Montreal and Quebec have a significant specialization in the derivatives market. We share that expertise, but we can look to Quebec for that knowledge base. Alberta has an oil and gas and natural resource orientation. BC has a very strong orientation towards small issuer capital formation. So with those regional viewpoints and strengths, and Ontario's strength as the home of the Toronto Stock Exchange and of many senior issuers, we're able to, reconcile viewpoints, taking into account these specialized capacities and produce a very effective result. And that's what the Policy Coordination Committee aims to do.
And I want to talk a bit more about policy relating to crypto assets in Canada. But first, I just have to note, earlier you said, you'd always aspired to have a strong role in policy in the securities markets. And you're doing that now. You can't do much more than that. It must be great going into work every day and doing something that you'd hoped to do when you were younger.
Oh, absolutely. No, it's incredibly exciting. And, the thing that's really striking about the OSC is the breadth of the team, the diversity of backgrounds, and having it truly the honor, to have an impact on securities policy and the outcomes that individual investors and securities markets achieve.
The reason why we're here is to talk about digital assets, crypto assets, how they're regulated in Canada. And the big question is, how are they regulated? But that's a bit too big of a question. I know the idea of a crypto contract is very important to how things are regulated in Canada. We have rules for exchanges. Could you talk maybe at a high level of how you think about regulation of crypto assets and how they are regulated in Canada right now, at least from a securities lens?
Yeah, we early on had the insight that for crypto asset trading platforms, that in most cases, investors are not holding the assets in their own digital wallets, but are really holding a position that's held by the platform itself. And those platforms initially, because they were in flight at the time that we began to explore regulation in this area, were not regulated entities themselves. You couldn't say they were functioning like a clearinghouse or a broker-dealer or an exchange in a traditional sense. So, and all of those types of infrastructure have really substantial protections behind them. So, in the absence of those protections, the bundle of rights that an investor holding crypto assets would have in relation to that platform, we treat it as an investment contract and security, and potentially as a derivative, because they weren't holding the asset itself. So using that crypto contract analysis, those who intermediated transactions or facilitated the trading, we were then in a position to design terms and conditions that were attuned to the specific circumstances of the entities and their involvement that allowed the innovation associated with crypto assets to move forward in a tailored manner through negotiation and dialogue with those entities. And as a result, we've been successful in registering a significant number of domestic and international platforms in Canada. And then, what followed from that was a need to consider involvement by investment funds in the crypto asset area. And I think it's well known that Canada moved forward with likely the first publicly available retail-oriented Bitcoin fund. And we did so before the US did. And Canada's had a long, long history of regulation in the ETF area and the fund space. So it's definitely a Canadian specialization. But having that foundation of regulation for the platforms and the ability to offer those securities to retail investors, we had that foundation, and then we were able to extend that into the fund space. And from there, try and move on with the industry in a number of areas of importance, including an analysis of stablecoin usage, decentralized finance, lending, staking, and many other areas. It's taken up a lot of time and effort at the OSC, given how prolific the crypto asset industry has been in coming up with new ideas that require regulatory attention.
That's a very good way to put it. Prolific and coming up with ideas that require regulatory attention.
Yeah.
I think that's fair. One thing that I found really commendable, and I remember when I was pretty early on in my career as a securities regulatory attorney, when the OSC said, hey, crypto platforms, come in and talk to us. We want to work with you to create some regulation. And this was in the aftermath of Quadriga, which I'm sure was a big part. And I want to talk about how that shaped sort of how you've approached the industry at the OSC. But I'd like to go even a little bit further behind that and just see, when was your first introduction to crypto assets? Do you remember when they first came on your radar? Was it relating to Quadriga, or had it been before that?
No, I had heard about it before that. And it was almost, I don't know, maybe it was our earlier conversation, but I'm thinking about it as like an emerging phenomenon where it's in the ecosystem. It's present, but you don't know much about it, but it's beginning to have an influence. And you're seeing younger investors in particular become attuned to it. And you're aware that they're entrepreneurs, kind of a new type of market participant, not the usual type of person involved in the securities markets, but someone combining innovation, having very little understanding of the traditional securities regulatory environment. So you had all these new entrants that weren't familiar with us, and we weren't familiar with them. And we're hearing about younger investors becoming attuned to it. It almost had initially in my mind an association with gaming, because it was kind of the same.
Video gaming?
Yes.
Oh, interesting.
Yeah. And then
right, because tokens, and it's a lot of the verbiage.
The verbiage was similar, and that was how it entered my imagination. And then Quadriga happened.
which wasn't a great thing for anyone who's involved in the industry. And I know the OSC, part of your mission is obviously to protect investors, and that's been an important thing too, is seeing what happened with Quadriga, what went wrong, and trying to protect investors from that.
Yeah, exactly. And when I think about it, even this gaming association, it sounds rather bizarre on the face of it, but it's actually quite relevant, because a lot of the initial speculative crypto assets had an underpinning of speculation and sort of engagement with the ecosystem that resembled gaming. And it sort of forced us to really consider, well, what is the difference between betting and investing when you're talking about an asset that has no intrinsic value, but has a value based on its potential utility or its future utility, very uncertain, or has, in some cases, just has a speculative appeal because of the name. And so the gaming association isn't completely unnatural. And then many of the same people in the crypto asset industry have now also been some of the early participants in prediction markets, which also poses the same issue of what is the distinction between investing and betting, and what type of securities regulation should apply. Like a gaming regulator often focuses on the risk of addictive behavior. Should a securities regulator, have a similar viewpoint about speculative assets in other dimensions? So, I do think this discussion about gaming and gamification is quite relevant.
Oh, especially I think now more than ever, a lot of people we're seeing the hyper financialization of sort of everything with prediction markets as well. And
Yes.
I did a podcast. It was about a 3-hour episode on prediction markets. And I spoke with a lot of people at the CFTC and sort of elsewhere in the countries about the regulations and the rules there. But what was interesting to me in my research was that this was something that had sort of been approved and was condoned by Wall Street. And the New York Times was referencing prediction markets back in the early sort of roaring 20s.
Right.
And before that, even in the 1840s. But what was interesting was where it diverged. When did that stop? And it was actually because people were confused about that with the equities markets in the 20s and prediction markets, the election betting, it really was at the time. And Wall Street wanted to separate itself because people weren't sure, because you're betting on how many cars Ford's going to sell,
right? Or
you're betting on how Ford's going to do as a company. It feels very similar. And in some cases it is similar, but it's still different in terms of what you're actually owning at the end of the day.
And I think that's the other, relevant policy consideration, the risk of confusion when you're having traditional equity investments, trading on, or the ability to trade it through a screen on your phone, along with sports betting, side by side, in a manner that doesn't really distinguish them, and in fact creates a blended experience. So I think the phenomenon from the 1920s still informs some of the discussions that we have to have today.
Just to step back for a second, why do you think we're seeing this gamification of financial markets? Why do you think people are going more towards alternative markets? Do you think it has something to do with how companies are going public even later? Do you think that's part of it? Or why do you think we're entering that space?
There are probably many factors, but but one of them is our association with technology and how integrated technology has become in our lives. So, these are technologically enabled offerings. The rise of social media has obviously been a primary driver. Again, financial advice, financial discussions occur with intensity in social media. And we've become creatures, much of the population, and starting with younger people, but now throughout all age groups are completely connected with social media. And the social media promotes connection with celebrity, and celebrity has become connected with prediction markets and the entertainment aspects of it. So I think the rise of social media, the connection with technology in our lives generally. And then I think there was, during a particular period, kind of a failure of the traditional finance entities to appeal to younger investors. There's a phenomenon that's well known in Canada and the United States that if you want to get financial advice from a larger organization, you have to have a minimum degree of wealth to support that activity, and that level has risen consistently over the last decade, and it's priced out smaller investors. And then you also have the phenomenon of groups that have traditionally felt excluded from the financial system, who praise the ability to participate in an alternative system. And that certainly helped crypto assets. I think it's had its real negative effects in Bitcoin terminals at convenience stores in disadvantaged neighborhoods. So you have that aspect too of disenfranchisement. So there is this element where traditional finance has priced people out of the market, and some people, disadvantaged communities, never felt integrated into the
Mhm.
financial system, and they saw an alternative system that came into being. So I think it's a sociological phenomenon that has to be analyzed in that light. So it has all those elements, and thankfully there are also many very positive components in the way this has moved forward in connection with efficiency and
Mhm.
opportunities related to crypto and the use of blockchain and decentralized finance.
Yeah, and I think that's an important point too. It's easy to get lost, and as someone who comes at it from a legal background, to identify all the risks, right? But there's
Right.
also a lot of benefits, not just with crypto, but also just with the world we live in today. I mean, our standard of living compared to 100 years ago is fantastic. But it's easy to get caught up in, oh, this is bad, because there are still a lot of things that need improving, but it's pretty good.
Well, that's right, and we're in this period of hyper change with technology and AI,
Oh, jeez.
and the phenomena we've been talking about, and it really highlights the good and the bad.
Yeah. Yeah. Well,
Yeah,
and one of, I think, the good things that came out of Canada was the ETFs. And like I've said before, if Canadians can get exposure to digital assets through something like an ETF, that can be a lot safer. For example, for my mother, who doesn't want to hold it in her wallet, she doesn't want to use an exchange, she just wants to hold it in an investment fund. Now she can do that. Are there other ways you think that Canada can make it safer for Canadians to interact with digital assets, and while also giving them access to these assets?
I think ultimately we have to rely on more advice, regulated advice in the area rather than do-it-yourself investing. So, you know, to date, most of the direct crypto asset investing has been do it yourself with advice from unregulated sources. And the way the traditional finance universe matured was by applying a fiduciary principle that facilitates portfolio management through regulated portfolio managers, through dealers that have know your customer and suitability responsibility, and through funds that have a strong fiduciary overlay. So I'd say the integration of crypto assets into the advisory
Mm.
functions is the way of improving the experience of Canadian investors in the space on a more informed basis. And that also requires us to apply regulation to those who are providing advice or services, but outside of that framework. Like we need to bring them with appropriate adjustments into that framework. But I do agree with your comment that having a portion of your portfolio based on the ultimately on the needs of the customer represented by ETF that represents one or perhaps a selection of crypto assets and subject to this overlay of a fiduciary
Mhm.
principle is probably the best way.
Well, and I think in the digital asset space in particular, it seems like, and I'm sure you've felt this way too, is the industry is relearning the lessons that traditional finance has learned over the past
It
120
feels that
years,
way. Yeah.
right? And custodial exchanges in particular are a good example of that. We saw with Quadriga. Why is it so important? And I know this, and I know you know this, but could you explain to people why it's so important that we have custodial exchanges regulated in Ontario and in Canada?
Well, in the absence of a well-capitalized custodian that has appropriate, procedures for safeguarding those assets, they really are at risk of loss with the failure of the firm or improvident transactions between the platform and affiliated entities. We've seen that happen in the past. So, one of the main safeguards that anyone can have in this space is to make sure that the assets are properly safeguarded and segregated so they're not exposed to failures by the firm or claims by creditors of the firm for activities that have nothing to do with the customer. The customer should be held whole, separate and apart from, failures of various kinds with the firms through which they transact and hold their assets. So having a minimum capital requirement, having adequate procedures, and having some type of insurance mechanism behind it are all sound public policy choices. It is noteworthy that in Canada, and I believe the situation is the same in the US, that the insurance provider for the securities for investment dealers in Canada, which is the Canadian Investor Protection Fund, does not insure or guarantee the crypto assets, but only the cash holdings that are at crypto asset dealers. So if there's a loss of securities, of most securities, debt securities or equities securities, the CIPF or the SIPC in the US provide insurance in case of the loss of those assets by the relevant firms. That was an important, long-standing reform in the US and in Canada. We still don't have that for crypto assets. So we have to instead rely on these other measures, including capital requirements, processes, regulatory examinations. But I think that's, it's really an important difference that people have to understand about the ecosystem. If you have a bank deposit, they're within monetary limits. You're protected by the insurance that supports retail bank deposits. But that's one area that still has to advance in the crypto space.
Yeah, and I was actually talking to someone about that, about stablecoins too, and the distinction. And I was asking them if they had FDIC insurance for their product, and they're like, well, we don't really need it because stablecoins need to be fully backed, whereas a lot of FDIC is for the fractional banking system. And not having those customer deposits, they hold, say, 10% of them actually at the bank at any time. So it's interesting how we're just seeing more competition in different areas emerge. And I think it's important to remember, too, that the OSC is not a merits-based regulator, right? And I think the Bitcoin ETF is a good example of that, where the OSC wasn't saying Bitcoin's great, everyone go buy it. It was saying, we're allowing this product to exist, right? And the market can decide whether or not it's something that they want to see. But I think oftentimes what the market doesn't always realize are the things that you've mentioned, which is safeguarding on the back end. Where are the assets? What protections are there for investors?
And with stablecoins, it's really the same, that we'll have to, we or a federal agency, some regulatory agency will have to verify the quality of assets that back the stablecoin on a one-to-one basis. And and there should also be an audit performed, that not only of the reserves, but of the financial condition, I would say, of the trust that holds those assets. And there's still, potentially the risk of affiliated transactions occurring. So there needs to be some, regulatory oversight to ensure that the promise of one-to-one backing is verifiable and maintained on a continuous basis. There are some stablecoin issuers that are reputed to hold a variety of instruments and not just U.S. treasuries or Canadian government bonds. So the quality of those reserves has to be examined.
It must feel a bit like whack-a-mole when it comes to the digital asset space for a regulator like yourself, because there's once some things get settled, something new pops up
something new pops up, and you feel an immense responsibility to keep up with it. Because if ultimately, if a regulated entity, if these problems materialize in a regulated entity, like, of course, we don't provide a guarantee or a promise, and it's impossible to protect against all events. But, clearly, investors, clients are better off dealing with the regulated space and with people grappling with these problems rather than, ignoring them and dealing with entities that are avoiding regulation.
And one of the ways that the OSC grappled with the problem of stablecoins, initially at least, was to deem all VRCAs, value reference crypto assets.
We're
a bit of a mouthful.
Giving up on that. It never gained traction. I think it was initially I was a little bit concerned that, of course, stablecoins, like a lot of terminology, has a kind of implicit marketing purpose. And of course, there have been experiences of where they haven't proved to be stable in some instances. So we thought value reference crypto assets was a more accurate description, but on a worldwide basis, we failed to have that catch on.
One thing that I think was important, though, that the CSA did do was take the position that, we'll call them stablecoins, are securities.
Right.
And now we have an act with the Stablecoin Act in Canada that seems to sort of regulate them as payment instruments. How is the OSC engaging with federal regulators to sort of work out how to move this forward here?
Well, we do have continuing discussions, but we too have to await what the federal government does in the regulations in that area, and focus on the areas within our jurisdiction that we consider to be critical. So, we continue to impose terms and conditions on regulated platforms that utilize stablecoins. And if an instrument is used in cross trading of crypto assets or in the crypto asset ecosystem on regulated platforms, we have a strong interest in ensuring sound regulation through the platforms that they've considered the appropriate issues for the use of stable coins on their platforms, and that they, through the platforms, ensure the one-to-one backing, quality of reserves, audited financial statements, and the rest. So we'll continue to do that. And, ultimately, no one wants duplicative regulation, but there's a space for securities regulators. And, clearly with the Stablecoin Act for the federal government and recognizing the use of stable coins as a payment mechanism.
Yeah, from my perspective, it looked like the OSC and CSA was saying, okay, there's no regime for stablecoins. Here's what we're going to do. We're going to make sure there's some sort of oversight here. People are using them. Canadians are using them. Ontarians are using them. And so now, do you think once we have a fully baked stablecoin regime, the CSA's role will change in terms of how it works now?
Well, I think our goal would be to avoid duplicative regulation, but we'll have to see how that evolves. So that, again, I think it's very important that an instrument that's used to facilitate trading be evaluated by securities regulators in connection with that secondary market usage and the role it fulfills to intermediate transactions. But I think ultimately there should be one integrated regime and no duplication.
That sounds good. Yeah. I think that'd save a lot of people work, both at the OC and at the Department of Finance and Bank of Canada and everyone who's...
There's enough work to go
There's around. Enough work to go around. That's for sure, especially given all the roles that you're juggling too. Do you have any thoughts on the stablecoin yield discussion? Something that I've heard come up in conversations with people is Canadian competitiveness. Is there a market for Canadian stablecoins? Does yield help bring that market up? You mentioned Canadian bonds, and how do we get more people holding Canadian dollars? How do we grow the value of our dollar? How do you think about stablecoin yield?
Well, it's a fascinating discussion. At one level, is a yield necessary for a stable coin to be characterized as a security? And we don't think so. In our environment, it could be, we would characterize it as a debt instrument. You have to even step back, why is a bank deposit not a security? It's because it's excluded by reference in the Securities Act. And why is it's excluded? Because it's subject to an alternative sound system of regulation. So, an unregulated debt instrument, which, if it were an unregulated deposit, which would be a debt instrument, would be subject to securities regulation because no one else is filling the gap. So a yield is not essential to be a security in our system, in our view. The public policy concern with yield is the effect on the banking sector, the competitive issue. And that, I think of that as kind of a national discussion that has to occur about the balance between decentralized system and one that would be under the supervision of federal bank regulators, and that has implications even for national monetary policy. Mm-hmm. So I wouldn't step into that, but I realize it's an area of intense jurisdictional debate and concern by regulators about the potential implications to the banking sector. And ultimately, as financial regulators, we all have to be concerned with financial stability issues. And, the protection of our own national currency. So
Mhm.
all of that is relevant.
Yeah, there's a lot.
Yeah.
There's a lot in securities regulation and in crypto as well too. And one of the things I just wanted to talk to you about was the OSC sort of role in over the past couple of years making decisions relating to crypto assets. And one of them that I was personally curious about was the decision to have a $30,000 limit on purchases on a single exchange
Right.
for all crypto assets except for four. And it was Bitcoin, Ethereum, I think Bitcoin Cash and Litecoin. And I was just curious, like, how does a decision like that come about? And what was the reason for having those not within that $30,000 limit?
Well, that was instituted quite a while ago now, and there was a lot of intense debate. But it sounds on the face of it restrictive. But if you go back to the crypto contract analysis, every time a platform issued or maintained a relationship with a customer in respect of a holding of a crypto asset, it was, in our mind, it was issuing a new security.
Mm.
So just from a purely technical standpoint, there was a new crypto contract created on each occasion. So what was the exemption for that transaction? For a retail investor, there is no exemption.
Mhm.
Wasn't subject to the
Right.
offering memorandum exemption, or, we could say the accredited investor exemption was available, and it is available. But for a non-accredited retail investor, the analytical framework led us to the conclusion that we needed to craft an exemption. So in a way, it was more permissive than the regime itself, which would have simply prohibited the issuance. So that was the starting point. And I don't think that's fully appreciated.
It's definitely not fully appreciated. I'm glad you explained that.
Yeah, no, it's pure. That was purely a technical analysis, and we viewed it as liberalizing. And then why did we distinguish Bitcoin? Because we were and Ether, among others, among the four, and they had already gained traction and had become quite commodity-like,
Mhm.
and so we were broaching the issue of whether those underlying instruments were commodities, and then you still had the contract element, but Bitcoin was becoming so extensively traded, and there were so many participants in the market that we thought it was unrealistic to impose the $30,000 limit at that point in time, that it had matured. But there was, frankly, a lot of debate at the time about, what would be the difference between a speculative junior company,
Mm.
equity security, and a crypto asset.
Mm.
But applying the crypto contract analysis, we thought we should be liberalizing to a degree, but recognize the reality that Bitcoin and Ether were extensively traded, and it would have been an unrealistic restriction for us to impose at that time. So we applied judgment in imposing those terms and conditions. But it wasn't an easy issue.
Oh, I don't think any of these are easy
Yeah.
issues. And that's why I commend the OSC for doing the hard thing, especially when it came to crypto platforms and welcoming people in, having conversations, creating rules. It's much easier just to ban something,
Right.
right? And just say, no, it's not allowed in our country at all. But it's a lot harder to go through all the steps that you guys did. Are there things that you saw industry do that were helpful that you would appreciate they did more of? Like, just thinking for people who are watching who might be coming at it from the industry side, what can they do more of to better engage with the OSC, with the CSA?
Well, I still think there's, somewhat of an aversion to dealing with the regulator. Of course, there was the U.S. experience where people engaged and were encouraged to engage, but there were no solutions offered. And the Canadian experience is very different. I just hope they're not intermixed. We've always been extremely open to a stakeholder discussion, and we tend to approach those discussions with intensity, but more informality and with curiosity. And then we don't view those meetings as, having an enforcement overlay or anything
Mhm.
like that. One of the things that really distinguishes stakeholder regulatory involvement in Canada is the ability to get a good hearing,
Mhm.
to get a hearing, to get in, to have informal discussions, to be part of the community. The US is that way now to a much greater degree, but I think people always find regulatory involvement intimidating. And one of the hallmarks of the Canadian system, I hope you'd agree, has always been openness.
Yeah, it's a very Canadian approach
Yeah.
to securities regulation.
So yeah, don't hesitate to come in and meet with us. And I think the investment we've made in understanding the space and the actions we've taken indicate a real desire on our part to learn, be curious, and to work with people.
And I think part of the hesitation from projects and certain people is if they're already doing something, they say, hey, it's going well, no one's being harmed, we're taking all the measures possible. If we go talk to a regulator, they might say, hey, well, this part of your business, we don't like this, it doesn't work, and it's outside of the law, which, to be fair to regulators, if you're offside the law, you're offside the law, right? And your job is to enforce the law. It's a hard dynamic for some that I've seen emerge.
Well, and also I think
on both sides, really.
Absolutely, and now there's a very experienced bar in the crypto asset area, but in the early days, you couldn't get advice from anyone, just like you couldn't bank.
Yeah,
and that's changing. So. And not, people who come up with innovative ideas, there's a chicken and egg problem.
Right.
Do they have enough money to pay counsel, to come in to make a well thought through presentation? So, we're happy to have very preliminary discussions. It can only go so far.
Yeah.
But we recognize this problem that, people need to get some regulatory input before they can get rounds of financing.
Yeah. And it's a win-win too, right? The regulators can learn more about how these new projects work, see where the risks may be. Maybe you flag to them, hey, this is how it's done in a different domain. You can apply that there. One thing I want to talk about is at OSC dialogue, there was an emphasis on balancing. I got to read this quote so I get it right. Balancing responsible innovation with essential investor protection and market integrity. How do you think about Canada's global competitiveness when it comes to a market like digital assets, when it comes to balancing investor and consumer protection versus promoting markets and having builders want to come here?
I think we're in a good space because it is balanced, but I recognize that the US is racing ahead in the crypto asset area and in a number of other, innovative areas. And that's always a challenge because of proximity and just because, the US is such a profound generator of new ideas. And, we have to customize it to any response to the Canadian system. And, the US is the largest capital market in the world. Canada is 7th or 8th, which is not small.
That's great. Yeah. I didn't realize we were that high.
Yeah.
That's really good.
We want to avoid any speculative excesses, and we probably want to go more slowly than the United States in the crypto asset area. It's more in the Canadian tradition to take a more experimental role, have things prove themselves, and then increase it incrementally. There are some areas where Canada is definitely a leader, such as the ETF space. We had the first traded ETF in North America. I think likely in the world, traded on the Toronto Stock Exchange many years ago before spiders became a product in the United States. We had TIPS, Toronto 35 index participations, that traded first. There are other areas Canada preceded the United States in decimalization of its market. We demutualized very early the stock exchange. And so there are many areas in which Canada can lead. And in the technology elements of crypto, Canada has had many of the leaders. And it's always difficult to see when they leave to go to the U.S. But the U.S. is such a magnet, and the U.S. system can facilitate that type of exploratory innovation in a way that can be a challenge given the Canadian approach, which is more incremental. But I do think there's an advantage in not having a big bang and being a fast follower in this regard, because the Canadian system is smaller,
Mm.
and it's and we're dealing with people's savings and retirement. So we have to be very cautious. So maybe it's a cultural regulatory difference, but I think we're better positioned in the crypto space to have moderate regulation and be a fast follower rather than go all in.
Well, it's interesting you say that because part of what I've seen too is us being a leader in a lot of respects. I mean, we had the ETF, the
Yeah,
Bitcoin ETF before the US. We also had regulation for exchanges before the US, and a lot of good came out of having all those
that's very
things in
true.
place. And so it's interesting to me to think about sort of the traditional Canadian approach as well too, because I've seen firsthand a lot of some of the smartest people I know who are Canadians, got educated here, moved to the US. And I'm curious how you think about that dynamic and that sort of the traditional, like you said, Canadian approach of incremental rules, when now it's easier than ever before to work remotely, to move across borders, to leave countries. Do you think we should be changing that approach and thinking about that in maybe a different light?
I think we should be pushing it to some degree in the direction of facilitating, more innovation and a willingness of Canadians for risk taking, but but without sacrificing this balance of innovation and market integrity and investor protection. That we should avoid going to, as the pendulum swings, we shouldn't go to an extreme. Uh,
I think
the
that's fair.
yeah, but a lot of systems around the world have and calls for deregulation, or the term innovation is described as an inherent good. Not everything that's new, you might say that everything that's new has the capacity to be innovative, but we have a strong risk orientation to protect retail investors in Canada. And I think there are speculative pockets within the crypto world. You just have to consider the various meme coins that have developed and failed, or other failures in the crypto asset area that makes us cautious that innovation just isn't used as a mantra for deregulation.
Yeah. And there's a lot of problems in this industry that are getting worked out, sort of like we saw with any industry, right? Trains, when Cornelius Vanderbilt was first putting steam engines on boats, they were exploding and
Right.
killing people. Imagine if we banned the steam engine,
Yeah.
right? Like we don't have trains, we don't have cars. And so I think it's so hard, the work that you're doing in particular and other regulators, to balance this. Okay, we don't want to stifle things, but we also, don't want steam engines exploding and
That's
killing
right.
people.
No, that's very true. And so experimentation is possible, and we have to accept that there'll be additional risk associated with that experimentation. But how much is too much? It's a very difficult call to make, and
How do you think about that call, Grant? Because I know it is a difficult call. Like what are some guiding principles that you keep in mind, or how do you even approach
well,
those
that's why
type
I
of
think
decisions?
sandboxes are really
Mm.
important. So like we're prepared, and we have an office that's dedicated, our innovation office, to test lab, to experimenting on a limited basis to see how things develop. So, in terms of tokenization, we recently had a project known as Project Samara that explored that involved a real issuance of a bond on a tokenized basis. The entire process involving custodian, a large Canadian bank, our involvement, the Quebec AMF's involvement, Bank of Canada, and EDC, the Export Development Corporation, as a bond issuer. And so we were able to explore all of the different facets of using the blockchain for an efficient process in bond issuance. And it was a very successful experiment. So I think our orientation is when something is new and has potential value. So it does lead us to have to evaluate, the potential value, since there's so many proposals, to do it in a confined manner, subject to terms and conditions, using our exemptive order authority, and keeping it within bounds before we let out into the wild. That's similar to the orientation in certain other developed jurisdictions, but I think there's a desire by the industry to do more on a big bang basis because things don't prove themselves unless they're done at scale. So in my mind, I like the experimentation and the confining of the risk, and then quickly rolling it out when we're satisfied. And I think the big bang approach, when so much is at stake in the financial system, can be really perilous.
Yeah. No, and it's difficult too with both approaches, right? The Big
Yeah,
Bang approach has its negatives, and a smaller approach too. If you build something in a sandbox, a competitor doesn't, they go elsewhere, they copy your product.
that's true too.
Right now, you've got this exemptive relief, but are you able to even win in the marketplace?
Can you give a first mover an advantage when it's being so transparent?
Yeah.
A big bang gives the first mover a tremendous advantage until it blows up.
Right, right. Yeah, it's a lot
Yeah.
to juggle, and the OSC is doing a lot of work. I think in that sort of dynamic, the CSA published a consultation paper on modernizing the regulation of public companies, which explores potential ways to support a regulatory framework that facilitates access to capital while balancing investor protection, sort of themes that we've covered on this podcast. Can you speak to the rationale behind publishing those initiatives now and what the OSC is looking for?
Well, it's really important that we focus on proportionate regulation, modernizing the regulatory system, because we are in a competition to attract capital and maintain capital in Canada. So we really need a very efficient system, and regulators should always be examining their traditional processes and seeing if they can be changed, whether some things can be taken out of the rule book, and whether even very fundamental concepts of securities regulation are still serving a valid purpose or have to be reformulated. In Canada, much like the US, although the US doesn't use this terminology of a closed system the way we have in Canada, we've always depended on having a concept of restricted securities and a holding period and seasoning period before securities that are privately placed, even by a public company, subsequently enter the marketplace. So, we have a 4-month hold in Canada for a private placement. And the reason for a hold period is, there are many reasons. One was to protect the public offering process, because essentially it could be a backdoor offering or distribution. We think underwriters perform an important role in the public offering process and in conducting due diligence. And if you didn't have a hold period and people were simply able to privately place securities and then distribute them, you wouldn't have the role of the traditional underwriter. There's information asymmetry that might exist that for those who might ultimately buy without a prospectus in those offerings. But we're questioning in this release what the role of hold periods are generally and whether they still perform the same function. So there's been an evolution in the markets toward less reliance on prospectuses, partially because there are fewer IPOs, more reliance on the quality of the continuous disclosure record and the responsibility of companies to release information, promptly about material changes in their business. So we're combining those two themes and examining whether hold periods are still serving their purpose, whether there should be a differentiation for offerings to certain institutional investors, and whether changes are needed in our regime for the disclosure of material changes and continuous disclosure to support that. So when you just think about those two areas, it's like it represents a fundamental change in the structure of securities regulation away from the primacy of a prospectus and in many other ways. And so that's just one among several areas that we're exploring in this release. And we're really looking forward to, commentary to help us design the regulatory structure in the future.
Well, and one of the areas I think that will be really interesting to see sort of how Canada approaches it and how the rest of the world does, and IOSCO as well too, is if we move into a world that, and I think decentralized finance is a bad name. It actually should be permissionless finance. Decentralized is a sort of amorphous term that that can have different meanings depending on who you talk to. But permissionless, the idea of more peer-to-peer transactions, intermediary-less systems is novel. And I've studied our regime. I've studied the American regime. You know it better than almost anyone. It's really evolved to have an intermediary in the middle. And the regulations are ensuring that those intermediaries, which traditionally were the source of all the risk, are regulated and are safe for consumers to deal with. How do you think we should be thinking about a future where we maybe don't have those, or they look different?
Yeah, it's interesting. It's actually, if you look at the Securities Exchange Act and they describe the purposes of the national market system, like one of their goals in the U.S. was to maximize the opportunity for investors to interact without intermediaries. So that goes all the way back to, I think, 1975 as a goal. I don't think they imagined permissionless trading completely, but you don't want unnecessary fee takers that create frictions in the system. So there has to be value in the intermediation function, and I believe in Canada there is that value, especially for retail investors. Again, you would want retail investors, you'd want to maximize the opportunities for advice. And you also want to avoid information asymmetry where, two people are transacting and the other has all the information.
Right.
So intermediation remains very important. And then if something is completely permissionless, it'll be harder to identify the participant and to regulate their impact on the marketplace. So there's a risk of manipulative activity, abusive activity occurring, where if it's concentrated in market intermediaries, it's easier to understand and respond to. So I, on the one hand, I think we should facilitate the reduction of the role of intermediaries, reduce the amount of unnecessary fee taking, but also promote the value of advice and the sound role performed by regulated entities. So somehow, through smart contracts or through direct oversight or otherwise, there'll have to be a new form of regulation applied to the participants in this less intermediated environment.
Yeah.
And that's going to be a challenge for regulators, but but it's one that we are going to have to fulfill, since I think that this trend is inevitable.
Yeah, it's interesting. The way I've always seen it is sort of the market will want sort of two things. There'll be someone maybe who's more like myself, who's more tech native, who's interested in taking on the risk of transacting peer-to-peer. I want to send you a stablecoin. I'll do it through my wallet. You'll get it through your wallet, and we go from there. My mother was a nurse for 35 years. She does not want to spend a minute doing any of that. Right. She wants to go to an intermediary. She wants to know that it's taken care of. She just goes in, logs in with her password, sends it over. She doesn't want that. The idea and the way I've always thought about it is there's a world for both of those things to coexist. And like you said, you have to look at the different risks that each presents.
I think that's true, except, behavioral insights will always indicate that all of us have a bias towards overconfidence. We believe we know more than we do about investing.
Oh, that's for sure.
So, how do you have a universe of people who are crypto native who want to engage, but might have that overconfidence, and they could potentially get scalped by people who have much stronger technological capability. Do we say we don't protect them because they say they want to fend for themselves? Should we have a way of accrediting them in some way to measure whether they don't need these protections? Or should it simply be self-certified and accept the risk of overconfidence and loss?
Yeah. Those are the questions.
Yeah, those are the questions.
Right. Because it's a hard one too, because on one hand, like I do believe, and I think, I don't know, to me, sometimes it comes down to how you think about people. Like I always see the best in people. And I think, if you are overconfident, like a lot of times overconfidence doesn't hurt people. If someone was overconfident in Bitcoin when the price was $200, they're okay now. If they were overconfident when the price was $150,000 and it's not, that's when it gets into some dangers. But the same thing is true in the capital markets and sort of any markets that you have. In the equities markets and oftentimes in crypto asset, it's a bit different where, Bitcoin might drop 20%, but it doesn't go to zero. You're not losing everything you put in immediately. Now, maybe you're using a software where you send it to the wrong wallet and that type of stuff can happen as well.
Well, that's true. There is that risk as well with of people controlling their wallets, and there is a rising amount of scams occurring where people are their permissions are being stolen.
Yeah.
Unfortunately, and that's a growing phenomenon, and one where it's very difficult to hold the platforms to account because people are overconfident and they're accepting something that they're seeing online and affecting these transfers. So that's a good example of the benefit of a more robust intermediary environment, with a lot of protections against that type of improvident transaction, and a good example of the highly negative effects of overconfidence and self-direction, I think. But we're going to have to deal with a more permissionless world, and I do think that investor education is important, but not enough. You need structural protections for individuals to protect against their worst instincts on occasion.
And so, that's something that I always have a tough time understanding, because on one hand, and maybe it goes to the accreditation idea that you came before. Like, I always found the accredited investor rules a bit unfair, saying that just because someone has more wealth, they're able to invest in, say, a startup that could do really well, could go to zero. But like we've seen with a lot of public companies over the past 5 years, they go public at $100. The stock's now at $5, basically lost everything as well too. So the risks don't feel too dissimilar, yet we're gating one form of these markets just based on wealth. Do you think there's a way we could in Canada see more of a merits-based test?
I think it's possible. I think, and I believe that could be facilitated by technology, there are different educational organizations that have developed like improved mechanisms for KYC to really understand the risk tolerance and capacity that individuals have, through not just by asking them how much can you lose, but by actually asking more circumstantial questions related to their lives and their plans and their aspirations. So you can use behavioral insights to garner that information and get a truer sense of someone's investment capacity and understanding. Like, you can ask a series, and we've experimented in this as well, and asking a series of questions that elicit investment understanding that would indicate whether or not they would understand more complex investments. So I think that's a really excellent frontier for exploration, where it's not simply the amount of money that you have, which is a measure not of sophistication in any way, but as simply the fact that you can lose a bit more before you're hurting.
Right. Yeah. And that's what they all came from. Now, we've spoken a lot about digital assets and crypto regulation. I want to turn to the other work that the OSC is doing to support our markets in Canada. It's not just crypto. For those listening, there's a lot more that you have on your plate. So I appreciate you taking the time not only to speak with me, but educate yourself on everything that's going in that market, because I do think it's important to have a free market and choice. And I think crypto does do that in to some extent and can remove intermediaries. Done rightly, it can be a really good thing. Can you tell me what else is the focus of the OSC at the moment?
Well, it really, I would say our primary focus, well, I'll mention two. One is competitiveness, so that traditional IPOs will take place in Canada in an efficient way when, the market demand is there. And we're seeing more of that activity taking place. But we need to, constantly improve in that area. So we've streamlined, for example, the financial statement requirements that in connection with company going public. We also have a number of exemptions in the exempt markets space, including the listed issuer financing exemption, which allows companies with that are public with an adequate disclosure record to issue significant amounts of capital, equity securities, and others based on their disclosure record on a really prompt basis. Again, going back to this theme of relying more on the continuous disclosure record
Mhm.
and not insisting on hold periods. So the life exemption in its current form has been incredibly successful with like over $3.5 billion raised using that exemption in a very short, just in the last year or so. So we're constantly trying to find more effective financing mechanisms that don't sacrifice investor protection. And we're focused on streamlining the public offering process to make sure it remains as attractive as possible so that, and then primarily with a focus, I would say, sometimes we have a focus on large issuers, senior issuers, but again, I want to emphasize that the Canadian market is really characterized by public SMEs,
Mhm.
and we really have to attune regulation to that. We're very focused on at the moment and have been for quite some time. So it's not just a response to U.S. developments, but we're examining the issue of semi-annual reporting, the burden associated with quarterly reporting, interrelating that to, our regime for continuous disclosure and seeing if eliciting comment on, whether we should, on a voluntary basis, move to a semi-annual reporting regime, like much of the world, and
Mhm.
as the U.S. seems to be doing. So, we're right sizing our efforts involving both the private market and public market. We recently introduced access equals delivery regime for public companies too that relies more on CDAR availability and pushing documents out to investors. So in almost every dimension, we're examining our rule book to look for streamlining. And actually, the competitiveness release that we were talking about a while ago doesn't mention crypto. So much of our conversation is related to crypto, but that release is really focused on public company and public company regulation to a very large degree.
And so, in terms of Ontario specifically, where do you see an opportunity for Ontario to expand our capital markets, access to capital markets, attractiveness of capital markets? I assume it's sort of the areas that you talked about. Is there anything we haven't discussed that you see as a big opportunity here?
Well, I think that in the same way that Canada is looking at diversifying trade opportunities, that we have been looking at mutual recognition and opportunities that arise in connection with similarly minded jurisdictions outside of North America. So we recently entered into an arrangement with the Hong Kong SFC, for example, that would allow Ontario and Canadian asset managers to sub-advise Hong Kong funds. And that was based on their satisfaction with the Canadian regulatory regime for asset managers. It created new opportunities for Canadian asset managers overseas. We recently, along with some of our CSA jurisdictions, and particularly the Quebec AMF, entered into an MOU with the French AMF to facilitate cross-listing of French and Canadian companies on Euronext and French companies in Canada. And people will be hearing more about that as we intend to offer seminars to facilitate more of an understanding. So there's a kind of an anti-globalization movement underway, but in trade and in financial services, the opposite is also true, that we have so much in common with our other IOSCO colleagues in developed jurisdictions. And while, the US will always be the primary magnet for Canadian issuers, there are opportunities in Asia and Europe that we want to make sure we can help them grasp.
Well, given the 30 years you've spent in the US, I'm sure not only that taught you about the American system, but it probably taught you what's so unique and what's special and what makes Canada a great country, and how to sort of keep that going and improve on that in the work you do now.
No, I feel that very, very strongly, and I think Canada has so many advantages that need to be, really explained and brought to the world. We have strong rule of law. We have strong professionals that support the system. We're the leader in mining finance on a worldwide basis. We have this particular ecosystem for publicly traded SMEs. We have so much innovation in the crypto area and other areas in Canada, and the innovators behind that. So I think Canada is really well situated, for a larger role in global capital markets, and we're fortunate that we have all those ingredients. We just have to more actively bring it to the world.
Yeah, no, I agree. Grant, I wanted just to end by just talking a little bit about your role personally and how you think about sort of your legacy. If you were to fast forward, say 10 or 15 years, and Grant Vingoe, CEO of the OSC, Vice Chair of IOSCO, what would you like to look back on and see that you've accomplished, or Ontario or Canada's accomplished in the work you're doing now?
Well, I will look back, I think, on the work we did in the crypto sector as being ahead of the game, and striking this balance, as difficult as it is, and that certainly came out in the conversation. We've also had structural changes at the OSC itself, led by our government, and I hope I will feel that I've navigated those changes very effectively, and also that I helped build on the culture of the OSC, so to break down different barriers and really promote what I refer to as a task force approach, where things are not siloed, but everyone is brought to the table with their expertise, and we produce unified decisions. So I'd like to think that the decision-making process at the OSC, has changed as a result of outside circumstances, but also, the way it's been managed by my team. And I just am extremely proud of the team and how they've applied a much more cohesive approach to decision making, are more agile, open to innovation, and that's built on a traditional OSC culture of excellence and curiosity. And I'll just be very proud if I built on that.
Why excellence and curiosity are foundations of the work that I do. It sounds like they're foundations of the work you do. So thank you for all the work that you do in our public markets in Canada and in the crypto space as well. I know it's a lot of work and a lot of things to do. You're not just a regulator, you're kind of a professional juggler, given everything that you've going on. So thank you for taking the time to have us here and to speak with me.
Well, I've really enjoyed the conversation, and thank you.
Thank you for listening to this conversation with Grant Vingoe, part 2 of the Crypto in Canada series. To support this podcast, please share it with a friend, someone you know, even an enemy, and take a look at the sponsors in the show notes below, which includes some of the top law firms in Canada and the presenting sponsor, Altitude. If you have any feedback or questions, suggestions for future Law of Code podcasts, or just want to complain about your favorite NFL team, you can always reach out to me at jacob@lawofcode.fm. Thanks for listening. Hope to see you again next time.